So, prenuptial agreements, what are they? Well, essentially, they are written agreements between two parties who are intending to get married. They focus on the financial arrangements between those parties both during the marriage and, more importantly, how any property and assets would be divided between them on any separation or divorce. The agreement is not legally binding on the parties until they actually get married. Is it enforceable? Well, up until the 20th of October of this year, I could have quite confidently said no, not in England and Wales. Up until that date, the courts have said that they would look at any prenuptial agreement and its terms, but would not feel bound by it at all. However, then came the Supreme Court decision in the case of Radmacher and Granatino. Whilst the tabloid headlines splashed around suggestions that prenuptial agreements would always be binding on parties from that date, I don't think that's absolutely true. However, the court did uphold the terms of the prenuptial agreement in this particular case. It also said that in the future it would uphold prenuptial agreements where the parties had entered into the agreement voluntarily, when there was no undue pressure on either of them to enter into the terms, and when they were both fully aware of the implications of the terms of the agreement. So what was this Radmacher case all about? Well, Mrs. Radmacher was an extremely wealthy German heiress who married Mr. Granatino, a French banker. They entered into a prenuptial agreement a few months before getting married, which effectively sought to ring-fence Mrs. Radmacher's vast wealth and stop Mr. Granatino trying to claim any of it upon any divorce or separation. Hey presto, on divorce, Mr. Granatino applied to the English court to try and get more money. 2 appeals later, the English court upheld the terms of the prenuptial agreement and awarded Mr. Granatino nothing more. However, it should be noted that this case involved vast wealth. Unfortunately, most of the divorce cases we deal with on a day-to-day basis have extremely limited assets and property, and we have great troubles trying to divide those between the parties in a fair way just to cover their basic needs, let alone have any surplus for the parties to fight over. So, can you enter into a prenuptial agreement? Well, yes, as long as you and your intended spouse both want to, then of course you can. Also, there should be no undue pressure on either of you. This helps if you enter into the agreement, say a few months before the wedding date itself and not just the night before. It is also a good idea for you both to take independent legal advice upon the agreement so that you're fully aware of the terms and the implications of the same. So what can you put in your agreement? Well, again, that's by and large up to you and your intended spouse. However, there are certain things that we would always advise you to put in. The first is what we call financial disclosure. That's setting out the financial position of you both at the time of entering into the agreement. This also helps you get independent legal advice upon what you're giving up, if anything, by entering into the agreement. You would also normally then set out the financial arrangements between you both during the marriage, for example, who's going to pay what towards the outgoings on the matrimonial home, and most importantly, you would deal with how the property and assets are going to be divided between the two of you on any divorce or separation. We would also advise you to have a trigger event or two of when you're going to review the agreement in the future, just to make sure that it's still fair and reasonable to you both. And one often used trigger event is if you had a child. Well, I hope this brief overview has been helpful to you. If you want any more information about prenuptial agreements or any other matrimonial matters, please go to our website, kerwins.co.uk.